Sorry, 001056.
That will be 1056.
Yes.
Yes, I'm there, Chair.
Now, this seems to me to be the whole problem with this, is that ordinarily you have a prosecutor who's the DPP. He looks at the work of other prosecutors who report to him, and then he says, look, your work has got discrepancies. I need it to be checked by a magistrate. And everyone is happy with that.
Yes,
And that's in the normal course of doing your work.
indeed.
Until somebody then introduces this theory, and I'm going to show you what actually seems to have been the problem. In paragraph 13, this is what Mr. Hali writes. Lieutenant General Mdluli was obviously anxious not to be prosecuted on either set of charges. To avoid prosecution, he had to make representations to two different persons, the Special Director of the Special Commercial Crimes Unit. Now, you were not involved in that one. That was
No.
Mr. Matenjo.
No, it was Mr. Mukwebe.
Sorry, Mr. Lawrence Mkhwebe.
Yes.
Now, and then he says, in respect of the fraud charges and the Director of Public Prosecutions in relation to the Ramukhebe matter, correct?
Yes.
And then he says, by March 2012, he had succeeded in doing so. The question is how? It is in this context that Advocate Chauke's decisions should be considered. Paragraph 14, the chronology of the events and the context in which Advocate Chauke made the decision to withdraw the charges demonstrates that in all probability he did not act without fear, favor, or prejudice in making the impugned decision. We summarize this case below. I mean, how do you respond to that?
That's a lot of nonsense.
No, well, let's not be rude. But how do you respond to that, that he is accusing you of not acting acting with fear, favor, or prejudice?
No, it's very unfair to me.
Yes, but it's false.
It's false.
Yes. Now, paragraph 15, on 7 July 2009, Lieutenant General Mdluli was appointed as the Divisional Commissioner of Crime Intelligence. His appointment was not made directly by the former President, Mr. Zuma, but it was made under highly suspicious circumstances which need not be explored here. Now, you know, I personally, as an advocate, cannot understand how you can make a statement like this without any underlying facts, because the opinion doesn't contain any facts that Mr. Mdluli's appointment was questionable.
But from what I understand is the theory that was developed because Mdluli said he was being prosecuted because they didn't want him to be appointed as the head of crime intelligence.
I understand that Mr. Mdluli can say anything. He's a witness. It's like Major General Boyson. I don't care.
Yeah.
What I care about is an opinion that is relied upon by the NDPP to prosecute you. And that's why I want your comment on paragraph 15.
It's just unfortunate that the opinion came with this theory, which is untenable.
But I mean, are there any facts here that support what is being stated?
No.
Yes. Now, then paragraph 16, Lieutenant General Mdluli and Advocate Jiba, the former acting NDPP, enjoyed a special relationship with and the protection of President Zuma, and both appeared to have a direct line of communication to the President. Now again, are there any facts here that now Ms. Jiba and Mr. Mdluli have a close relationship to the President?
Not that I'm aware of. Advocate Hali would have...
No, in the opinion.
No.
Yes. But what is the basis then for this?
There is no basis at all.
Yes. Now, then, Advocate Jiba repeatedly told officials within the NPA and spoke openly within the NPA corridors that she had the ear of the President. Lieutenant General Mdluli lodged complaints with former President, and it seems that his complaints were taken seriously. We explore that below. Again, is there any basis, factual basis set out here for this?
No.
Yes. And then, paragraph 17, on 8 September 2010, President Zuma granted Advocate Jiba's husband, Mr. Buka Nancy, a presidential pardon despite warnings from the Minister of Justice, Mr. Jeff Khadebe, that Mr. Nancy had not met the most basic requirements for such pardon. This evidence is documented in an affidavit of Advocate Karen van Rensburg that was filed with the State Capture Commission and appears on its website. This case is amply supported by the documentation attached to her affidavit.
No, there you have it.
What do I have?
That the theory came from Karen van Rensburg.
Yes.
Yes.
Advocate Karen van Rensburg.
Sorry, Advocate Karen van Rensburg.
Yes. But it's not tested anyway. There's no trial. There's no cross-examination. Nothing. It's just people's own thumb-sucking.
Yes.
Yes. Then, a day later, a person bearing the name of Jiba, and this is really, you have got to look at this. It's truly astonishing what is said here. A day later, on 9 September 2010, a person bearing the name of Jiba, who apparently had a different identification number, and Lieutenant General Mdluli traveled together on a flight to Durban. Advocate Jiba was confronted with this evidence in the Mokgoro Commission of Inquiry. She denied that the person in question was her. Given the surrounding circumstances, it seems, with respect, far too coincidental that it was not her. Now, what do you make of this?
It's very unfortunate.
But in terms of the evidential quality that you would expect from a senior counsel advising the NPA, that you just rely on your own speculation.
That's why I'm saying that he looked at the gossip and the innuendos from people in the NPA, like Advocate Karen van Rensburg. You would remember Advocate Karen van Rensburg is the one who filed the affidavit in the where the NPA was alleging that it was not represented in this inquiry, when the contrary is correct. So I'm not surprised at all.
Yes. Then, on 11 November 2010, Lieutenant General Mdluli addressed
Sorry,
it.
before you continue, all these allegations that are being mentioned, especially at paragraph 17 and 18, went to the State Capture Commission.
Yes.
Do we know whether there was any pronouncement on any of this, or what was the outcome? I'm looking at paragraph 17, where it is said that Mr. Nancy, whom we know that it's Advocate Jiba's husband, was granted pardon despite warnings, and that he had not met the most basic requirements for such pardon. Did the State Capture Commission make a pronouncement on this, or was there an effort to review this decision? Because if it was taken arbitrarily, it is an administrative decision that can be reviewed. Was there any pronouncement, or was it reviewed? And maybe let me just lump it with what is contained in paragraph 18, where Advocate Jiba says, the person that you're talking about is not me. Was there anything further done to try and prove that it was Advocate Jiba for us to be dealing with it now, entertaining it now here?
Chair, not that I'm aware of. As indicated when Advocate Shamila Batoyi testified here, she said regrettably the Zondo Commission did not make any findings. Now, what has happened here, because I also filed an affidavit at the Zondo Commission, when it was supposed to be our turn to respond to the allegations from Karen van Rensburg et al. The Zondo Commission said this was not within their terms of reference, and then they will refer them back to the NPA to be dealt there. That's why when she was Advocate Shamila Batoyi, when she was here, she said, regrettably, Zondo Commission did not make any findings.
So the NPA did not do anything after being told by the State Capture Commission that this is outside their terms of reference?
Not that I'm aware of. What had happened thereafter is this process that we are in now.
So we can simply disregard this because it does not take us anywhere. I mean, we do not have to. Advocate Jiba is not before us. it's only her decision in relation to the Katomena that is before us. But other than that, the rest of this are not relevant to our terms of reference, unless if they show something that I'm unable to grasp.
Chair, they just saw the appetite that Advocate Karen van Rensburg, Advocate Batohi, some civil society groupings they had at Jiba. This is what I can sum it that way. This appetite about her and what have you, I don't know.
Thank you.
May Council, the issues referred to at RM 00883, that the cryptic issues, you remember? The 6th paragraph that Advocate Ncukaitobi referred to earlier?
883?
883, RM 00883 is volume 4 of Mdluli. It's a prosecution memorandum. In which representations by Advocate Mdluli, yes, Advocate pardon, General Mdluli, yes. The first issue regarding the murder charge and the attempted murder charges, they say, was based on circumstantial evidence.
Yes.
It is for that reason that you referred the matter for inquest.
Yes.
Can you just elaborate for those who do not understand what circumstantial evidence is?
Yes, Chair. Circumstantial evidence shows that you don't have direct evidence to link the accused with a particular offense. You rely on circumstances and inferential reasoning to conclude that this might be the person who is responsible. Now, in that kind of reasoning, when you reason, you must exclude other possibilities in respect of that circumstantial or inferential reasoning. At the end of the day, circumstantial evidence, at times you will have some facts outside of that which might corroborate that circumstantial evidence. And in this instance, my reasoning was that there are no other facts other than that there is this love triangle, which is supposedly the main cause for his death. And once one reason with those kind of circumstantial evidence, you must draw the conclusion that one inference which points to that. And in my thought and in my reasoning, that was not the only conclusion that one could reach based on the facts as I had them at the time.
Will I be correct, given in your experience as a prosecutor, a very experienced prosecutor, that when we are faced with circumstantial evidence and you have to make a decision whether to prosecute or not, or to go to trial, proceed to trial or not, you often encounter challenges in formulating a conclusive view that there is indeed a prima facie case.
Indeed, Chair.
Am I correct?
You are correct, Chair.
Now, with this background, looking at the opinion of Advocate Halley, where they tabulate all these things that they are mentioning, which seems to me to constitute gossip.
Indeed, at the highest level.
Is there any way in this opinion, I might have misread the opinion, wherein the writers of this opinion deal with those aspects of the circumstantial evidence
Not
of the
that I'm
case?
aware. Not that I'm aware, Chair. I tried to also go through it from time to time when I knew that I was going to come here, and I couldn't really see where they actually discussed the actual effects and the actual evidence.
In the absence of any analysis of the circumstantial evidence that you were confronted with, that might have assisted in coming to a reasonable conclusion whether you were wrong or not. What do we then make of this opinion? From those paragraphs where reference is made to you having acted, that you did not act without fear, favor, or prejudice, that you relied on those things that have been mentioned in those paragraphs, without the analysis that I'm mentioning, what should we then make of these paragraphs?
I respectfully submit that they must be ignored and not be taken into account, because it's untenable and not based on evidence, what is contained on those paragraphs.
Now, the suggestion at paragraph 14 of the opinion that in all probability you did not act without fear, favor, or prejudice, you know that is a serious allegation.
I know, Chair. And
it is serious because of your constitutional and legal obligation as a prosecutor, correct?
Correct, Chair.
Now, the averments that you did not act without fear, is it based on those paragraphs? For instance, paragraph 15 and 16 regarding the mentioning of the appointment of Mr. Mdluli by President Zuma, and that General Mdluli had a relationship, a special relationship with Advocate Jiba, that Advocate Jiba's partner was given presidential pardon. I'm just mentioning in summary those aspects. And I'm just trying to determine what relevance are these aspects to the allegation that you were fearful.
To the contrary, I was not fearful for that simple reason that if I was acting with prejudice and the like, and I was to confirm to this theory, then it means I would simply have withdrawn the charges against Mdluli in their entirety. But because I was acting without fear or favor or prejudice, I had to look at the facts and satisfy myself that there is justification for the charges, one way or another. In summary, Chair, I acted without fear or favor or prejudice.
Hence
because this reasoning, which is here in this paragraph, is prejudicial in themselves.
And it's not consistent with your decision referring the matter for inquest.
Indeed, Chair.
Yes, thank you.
Thank you. Mr. Chauke, let us not poison this forum further by emphasis on the gossip.
Thank you, Chair.
I just want to answer something directly on this line that the Chair was engaging you with, which is, you know, if it was true what Advocate Harley has written there, all of that gossip, what did you actually do? Now you've got the results of the inquest. They say that on murder, it's no good. But what did you do, as a matter of fact?
I did nothing wrong, Chair. because immediately after the findings of the inquest, I called in the prosecution team to say, here we are. You guys must now amend your indictment and proceed with all these other charges.
Yes.
Then the team leader, Advocate Fansel, he says, no, I heard that your decision to refer the matter to for the inquest is being reviewed by the High Court in Pretoria, and in that sense, we cannot proceed with the matter on trial given under the circumstances, which I agreed with him because it made sense that one will have to wait for the judgment from the High Court, which was delivered by Murphy J.
Yes.
And then after the judgment was delivered against the NPP, that decision was appealed to the SCA. And the SCA came out with the judgment that determined that my reasoning and the process that I followed was rational.
Yes. But also they affirmed you on the fragmentation issue.
Yes.
Insofar as they're talking here about the delay in the other charges.
Yes.
Yes. But the point I'm saying is, what did you actually do against Lieutenant General Mdluli? You remember that this is the person via gossip that they are associating you with. And Advocate Jiba and President Zuma, the whole conspiracy that they have cooked up at this Advocate Van Rensburg's affidavit. But you have a choice to say, am I charging this person? Because if you are part of this large conspiracy, what did you actually do?
No, I charged Mdluli in respect of all the other offenses of kidnapping, assault, and on the victims. If I really had anything to do with him that was protecting him, or probably I would have found a reason not to proceed with those charges, given that there were even more than 11 years, which is irrelevant. The fact of the matter is, I was faced with a decision to make there, and I made it accordingly without any fear of ever prejudice.
But as I understand, you are, in fact, the only person who's ever charged Lieutenant General Mdluli.
Yes.
And then what happened after that? Once you charged him, he went to a trial?
He went to a trial, and they were convicted, and they were sentenced to 5 years imprisonment.
Yes.
Yes.
Which has never happened before.
Yes.
And then the only person who ever charged Lieutenant General Mdluli is now being accused here, strangely, of trying to protect him. But you sent the man to jail for 5 years.
Yes.
Yes.
During the testimony of Advocate Batoi on this aspect, when we asked her as to what the problem is in relation to you having withdrawn the murder charges, my recollection, subject to correction, was that she said you did not reinstate the charges.
Yes.
If my understanding is correct, she meant, unfortunately, she left before we could canvass those issues with her. My understanding of her testimony was that your failure to reinstate those charges after the decision of the Supreme Court of Appeal is what really gave the problem and led to her doing what she did. Because she seemed to have understood that withdrawal per se does not put an end to a case, a criminal case. It can, at a later stage, be reinstituted. Is my recollection of events correct?
They are correct, Chair. What has happened, as I indicated, there is a misreading or misunderstanding of the judgment. Once the SCA made the judgment, it took the decision to decide on the murder and attempted charge back to took it to the national director. I couldn't, in terms of that judgment, make a decision myself, because that decision became now the decision of the NDPP to make, which he made. So how Advocate Batoy and those around there could consider even the opinion conclude that I failed to reinstate the charges once they were withdrawn, it's beyond comprehension.
If you can just, maybe if you remember where we find Brand J's order. Brand J.A.'s order, rather.
It is CL. Where is CL? CL 00371. That's CL2.
00371.
71.
Thank you, Council.
I'm there, Chair. I got it.
Paragraph 54, it's the order of the Supreme Court of Appeal. Would you just quickly read the order?
Thank you, Chair. In the premises, it is ordered that 1, the appeal succeeds only to the extent that paragraphs B, E, and F of the order of the court are set aside. 2, the orders in paragraphs A, C, D, G, and H of the order by the court are confirmed, but renumbered in accordance with the changes necessitated by the setting aside of the orders in paragraph 1. 3, it is recorded that the following undertaking has been finished on behalf of the first appellant. A, to decide which of the criminal charges of murder and related charges that were withdrawn on 2nd February 2012 are to be reinstituted, and to make his decision known to the respondent within 2 months of this order. B, to provide reasons to the respondent within the same period as to why he decided not to reinstitute some or if any of those charges. 4, there shall be no order as to costs in respect of the appeal.
As regards Order 3A, as you mentioned, the matter was now in the hands of the NDPP.
Yes.
This time it was Advocate Nkasana, correct?
It was Mr. Ngasana.
The matter was now out of your hands.
Yes.
Thank you, Council.
Thank you, Madam Chair. Can you go to your bundle where there's your statement together with its attachment, and go to page 6A 161?
Maybe before we go through that bundle, I should ask questions. I thought you're still going to be working on this portion, but then, yeah. Advocate Chauke, you say that your decision was different from that, or your view was actually different from that of the prosecution team that was looking at the Mdluli matter, the matter in particular.
Yes.
Am I correct? And you engaged the prosecution team about what is concerning to you, and nevertheless, as a cautionary measure, you took this matter, you referred it for inquest.
Yes.
And you say that the members of the prosecution team, the very prosecution team that had decided that the matter should be proceeded with on prosecution, are the ones that led witnesses' evidence at inquest.
Yes.
At the inquest, yes.
Yes.
And once the inquest was concluded, the magistrate gave its ruling, its decision.
Yes.
Now, do you know as to, upon receipt of the decision of the magistrate, what was the view of the members of the prosecution team, the very ones that were actually active at the inquest? Were they satisfied, according to your observation or even what they said, about the decision of the magistrate, or was there any issues from them?
According to me, they were satisfied. They understood the reasoning of the magistrate, and I did not take it any further from there.
Okay, yes. So they too now were satisfied with your thinking and agreed, based on the reasoning of the magistrate, that you were actually correct.
Yes.
Now, after the receipt of the inquest outcome, you then directed the prosecution team, Van Zyl and them, to then proceed with the other matters.
Yes.
And how can we describe this? Can we say that you gave a directive that the other matters be proceeded with without delay, or did you delay in some way or the other?
I did not delay it at all. I think it was 2 or 3 days thereafter, once I received the record of the findings from the magistrate, and having studied that, I called the prosecution team, and I explained to say, given what has happened and the reasoning of the magistrate, I'm satisfied that the decision that I've made is correct. You can proceed with the other charges.
So this actually suggests that the question whether to proceed with these other matters depended on what the outcome would be, but in respect of those matters, you were resolute on proceeding with the prosecution. The only thing that you were trying to avoid was staggering the matters. Is that a correct conclusion?
That is correct, yeah.
And would you say that the NDPP or the NPA actually ought to have become aware of the fact? Let me rephrase it. I don't think I'm asking that. Right. Now, but for the advice from the prosecution team that the decision of the magistrate was, the judgment of the magistrate was under review, these other matters would then have been proceeded with.
Yes.
Now, reference to, I see Advocate Hali's opinion has spent a lot of time dealing with issues that concern Advocate Jiba. And I look at that memorandum, that opinion. It was written in 2023. Is it correct that that was long after Advocate Jiba had left the NPA?
Yes.
Thank you.
And Mdluli and the others were by then, I think they were in prison, serving the 5 years.
Right.
Yes.
Thank you. That's a bonus answer. Thank you.
In relation to which charges?
In relation to kidnapping, assault, and defeating the end of justice charges.
Yes.
And you may?
No, I'm happy to yield.
Yes,
Madam
thank you.
Chair.
And I thought that the point that I asked you about Order 3A of the Supreme Court of Appeal, just to take it to its logical conclusion, the charges were subsequently reinstated.
Yes.
That is the murder charge.
No.
What happened to those charges?
Mr. Ngasana made the decision that there is no enough evidence to proceed on the murder and attempted murder charge, and he informed the freedom under law accordingly through Cliff Decker attorneys.
What decision then did he make? Nolle prosecu?
He made a nolle prosecu in respect of murder and attempted murder charges, and indicated that the trial is going to proceed in respect of the other charges as directed by me.
Yes. Was there any challenge to that decision by anybody?
Not that I'm aware of.
Thank you.
Thank you, Madam Chair. I think we were actually on the same point. I was going to ask the witness to look at 6A/161 of the attachments to your statement.
Yes, I'm there, Chair.
Yes. What is that document?
It's a letter written by Mr. Ngasana, the National Director of Public Prosecution, to Tricia Erasmus, Senior Associate Cliff Decker, Hofmeyer Incorporated, dated the 17th of June, 2014.
And then can you just read the contents of that document?
Dear Tricia, the above matter in your letter, facts dated 5 June 2014 refer. Kindly be advised that after careful consideration of the evidence contained in the dockets as well as the transcription of the inquest record, the state has taken a decision to reinstate the following charges against Mr. Richard Mdluli. 1. 5 counts of contravention section 1, subsection 1B of the Intimidation Act 72 of 1982. 2. 2 counts of kidnapping. 3. 2 counts of assault with intent to do grievous bodily harm. 4. 2 counts of assault common. 5. 1 count of defeating and/or obstructing the end of justice. Due to the high-profile nature of the matter, the state is considering arraigning the accused in the High Court. Please take note that the state is not in a position to proceed with the murder and attempted murder charges against Mr. Mdluli at this stage, due to the lack of evidence implicating him thereto.
If you can just
Please.
stop there. No, just stop there, because he's then talking about fraud and corruption, which was Mr. Mkwebi's department. Your department was murder and attempted murder.
Yes,
You had come to the exact same conclusion yourself earlier.
indeed.
And now your boss also comes to the same conclusion after reading the dockets.
Yes,
Now, the funny thing here is a withdrawal doesn't mean the end of the prosecution. You can reinstate if you find the evidence at a later stage.
yes,
After Mr. Ngasana left, there was another NDPP who was Mr. Sean Abrahams.
yes.
Did he reinstate the charges of murder against Mr. Mdluli?
No,
After Mr. Abrahams, there was another NDPP, Advocate Patoi, who seems to have been concerned about the withdrawal of the case. Did she reinstate the charges?
no, she did not. That's why I make it in my statement there to say, even as I'm sitting here today, she has never taken that decision to charge Mdluli with murder and attempted murder.
Yes, and does murder prescribe?
No,
Yes. So she had 7 years to charge Mr. Mdluli if she believed that there was a good case against him, and she didn't.
indeed.
Yes. Sorry, you wanted... Sorry.
Just to follow up on that one. Advocate Batohi, in her evidence and also even in her affidavit, she states that you weakened the murder charge by delaying prosecution. Are you able to help us understand what that means in the context of your work as a prosecutor?
No, to the contrary. One was able to determine whether that theory or the circumstantial evidence would stand scrutiny in court, which it was not. So she's saying directly the opposite, because the opposite will also be true, that at the inquest, it could be that the evidence there will come and show that indeed this circumstantial evidence is strong, and then it's the only inference that can be drawn that Mdluli who killed Ramokhibe at the exclusion of any other person.
Can you enlighten us about what could weakening a case mean? especially in the context of your exercise of your obligations as a prosecutor. Instances where we can really point out that indeed these are factors which can contribute to the weakening of the case at the hand of the prosecutor.
You will find the rare instances of that happening, because in a case where a witness is subjected to double cross-examination, that is cross-examined at the inquest and then being cross-examined in the actual trial, there is a potential that you think that the witness may contradict themselves in the subsequent trial and the like. That's the only reasoning that I think maybe she was thinking about it.
Yeah,
Anything more than that, it will be a figment of an imagination that will happen.
Okay, thank you, sir. Thank you.
Thank you.
Ncukaitobi, I'm reminded that it is tea time.
Yes.
But before we pause, let me just clarify with the witness. Following the letter by Advocate Nkasana, or decision, let me not refer to it as a decision, 6A-161, where he said, please take note that the state is not in a position to proceed with the murder and attempted murder charges against Mr. Mdluli at this stage due to the lack of evidence implicating him. You said that this is a nolle prosecute decision. You understand it to be that?
Yeah, I understand it to be there at that stage.
Now, what avenues were or options were open to Advocate Batoyi if she was of the view that the murder and attempted murder charges against Mr. Mdluli should have been proceeded with?
If she had evidence which would have come to light between then, when Mr. Nkasana made this decision and her coming into office, she would be entitled to reinstate the charges, to make a decision to say the murder and the attempted murder charges should proceed.
That's where my problem is. I don't understand this sentence to mean withdrawal.
Yes.
I understand this sentence, and correct me if I'm wrong. The decision Advocate Nkasana is taking here is not a withdrawal.
No.
It's a nolle prosecute decision.
Yes.
Now I'm asking you, in the face of that kind of a decision, in your understanding of criminal proceedings, what options was then open to Advocate Batoyi if she was of the view that the prosecution should have been proceeded with?
It was to go back to the court and ask for the court to review the decision and consider factors that she would have had in a position to indicate that that decision was unlawful or was irregular. In the same vein that freedom under law went to court to challenge the decision not to prosecute, she could have done exactly the same way to indicate that she wants that decision reviewed, and then that the court will consider and make a decision.
But the freedom under law one was different because yours was a withdrawal.
Yes.
Not a decision not to prosecute.
Yes.
Is my understanding correct?
Correct, Chair.
Here, it is a final decision, if I may call it that, not to proceed with the prosecution.
Yes.
And in that instance, anyone who was of the view that the prosecution should have been proceeded with would have taken certain steps. And you say Advocate Batoyi should have gone to court to review this decision of Advocate Nkasana.
Yes. Or freedom under law then, when the decision was made and they were not satisfied, they would have approached the court for them to challenge that decision of Mr. Nxasana.
Yes, freedom under law is not before us. There's no complaint by them. The complaint is by Advocate Batoyi.
Indeed,
That-
Chair.
Yes. We have now crossed that first hurdle regarding the withdrawal by you. The SCA has pronounced on that. The matter has now gone to Advocate Nxasana, the NDPP, in whose hands the matter was, and he decided, I am not proceeding.
Yes.
That should then have brought the matter to an end.
Which is what has happened. The matter was concluded then.
Thank you.
Thank you, Madam Chair. Sorry.
Yes, the matter was then brought to a halt by the Nole Prosequi, as my sister has stated, that, I mean, there is a clear difference between a withdrawal and you cannot exercise certain powers in respect of a withdrawal. Is it also not so that maybe the only option open for a person, not just focusing on Advocate Batoyi, because then we'll talk about her office later if necessary. Once a certificate of Nole Prosequi has been issued, is it correct that those who have an interest in the matter would then have a right to institute private prosecution proceedings?
Yes.
But looking at the office held by Advocate Batoyi, would that, even that, be open to her? Because people go for private prosecution because they think or they believe that the prosecutor has failed to exercise its decision properly. And the decision that comes from the NPA becomes the decision of the NPA.
Yes, she's functus officio.
She's functus officio, and
Yes.
she would not, that would also not be open to her.
Yes.
Thank you.
Yes.
Just the last question. On that aspect of the terms of reference, reference term 3.1.2,
I'm the chair.
if I may quickly just read it, the failure to continue with charges against Lieutenant General Richard Mdluli for his involvement in the murder of Mr. Tefo Abel Ramogibe, in that he, Advocate Chauke, caused the charge of murder relating to the killing of Mr. Tefo Abel Ramogibe and related charges to be withdrawn.
Yes.
We have crossed that hurdle.
Yes.
Notwithstanding that there was strong evidence justifying the institution of a prosecution in the matter, we also dealt with what seemed to have been relied upon by Advocate Hali and others in the opinion that gave rise to this issue. Is there any other evidence, in your view, apparent from the affidavit of Advocate Batoyi, other than what we have read in the opinion of Advocate Hali, suggestive of a strong evidence?
No, Chair. Even from the prosecution team themselves, they've never used this word strong evidence. They said there was circumstantial evidence.
Well, we will probably have the benefit of hearing from Advocate Batoi if she decides to come back and take that stand, or from any other witness who may assist us in establishing whether indeed there was such strong evidence referred to.
Indeed, Chair. It would be nice to hear the legal mind of Advocate Shamila Bato in that respect.
Yes, thank you. Council, I don't know whether you want to close this chapter or you want to deal with other aspects. If you want to close it with few questions, maybe we should do that so that you can lap into the last few aspects of your case, if necessary.
Yes, Madam Chair. No, it's just to go back to the prosecution memorandum, which is the source of this. It's actually at RM 00883. The witness points to the fact that the charge talks about strong evidence, and it is disconnected from the prosecution memorandum, which is the basis on which they are relying. Now, if you look at item 1 under issue 2, strength of the state's case, it says the case on the murder charge relies solely on circumstantial evidence. Those include a threat by the accused to the deceased family that the deceased will be killed. Now, then, if you look at item 4, which is actually, I think that actually the attempted murder charge is irrelevant because it's not in the charge. The only issue to be concerned with is the murder charge.
I take it when they say and related charges, when you read the terms of reference, that's how.
No, but where do they say related charges?
Where they say a charge of murder relating to the killing of Mr. Tefo Aberamkhibe and related charges to be withdrawn.
So you would read related charge to be murder and attempted murder?
Yeah.
Okay, well, we can take that generous view. But then in paragraph 4, we are still back to where we started, paragraph 4 of the prosecution memo. It says the attempted murder charges, count 13 and 14, are also based on circumstantial evidence.
Yes.
So this is where the disconnect is. And then you look at the charges. The charge then invents a phrase, strong evidence.
Yes.
But that was not the opinion of the prosecution team.
Yes.
Yes. Madam Chair, I'm just going to do literally the last 3.2, which are the conclusions, and then I would like to stop so that we can have enough time for the cross-examiners. So if I could just do that quickly in 5 minutes before we adjourn.
Council, I think you should then finish.
Yes, thank you, Madam Chair. If I can take you back to your terms of reference.
I'm there, Chair.
So in paragraph 3.2, they say, whether in fulfilling his responsibilities as Director of Public Prosecutions, Advocate Chauke complied with the Constitution, the National Prosecuting Authority Act, and any other relevant laws in his position as a senior leader in the National Prosecuting Authority, and is fit and proper to hold this position and be a member of the Prosecutorial Service. What is your answer to that? Did you comply with the Constitution? Did you comply with the NPA Act? Are you fit and proper?
Fully. I complied fully, and I'm fully fit and proper.
Yes. 3.2.2, whether Advocate Chauke properly exercised his discretion in relation to instituting and conducting criminal proceedings on behalf of the state, carrying out any necessary functions incidental to the institution and conducting such criminal proceedings, and discontinuing criminal proceedings. Did you properly exercise your discretion in relation to those three aspects?
Yes, Chair, I did.
Yes. And then whether you duly respected court processes and proceedings before the courts as required by the applicable prescripts, and as a senior member of the National Prosecuting Authority, did you respect courts?
I respect courts directly opposite those who came before the inquiry because they don't respect the courts.
Yeah, well, they're asking you to revisit court findings, so
Yes.
that says a lot.
Yes.
And then whether you exercise your powers or performed your duties and functions in accordance with the prosecution policy and policy directives as determined under Section 21 of the National Prosecution Authority. Did you respect prosecution policy and prosecution policy directives?
Yes, I did, Chair.
Whether you acted at all times without fear, favor, or prejudice. Did you act without fear, favor, or prejudice?
Indeed, Chair.
Whether he displayed the required competence and capacity required to fulfill his duties by, among others, objectively engaging the facts presented to him impartially, in good faith, and without fear, favor, or prejudice, subject to the Constitution of the Republic of South Africa and the law, in order to discharge his duties as a Director of Public Prosecutions. Did you fulfill your functions in accordance with the required level of competence and capacity?
That's my view, that I fully complied with that.
Yes. And then whether he acted in a manner which brought the National Prosecution Authority into disrepute by any of his actions or omissions. Did you bring the NPA into disrepute?
Not at all.
Yes. Now, will you, I understand that you've obviously not been happy that you've been suspended and you've been subjected to an inquiry and you feel there's a lot of unfairness.
Yes.
But the fact of the matter is that if you are not found guilty, you have to go back to the NPA.
Yes.
And you have to work with some people that you would feel have been unfair to you. Advocate Karen van Rensburg is one of them that you've specifically mentioned. I don't know if there are others, but Advocate Batoy is gone, so there is no issue there. But you have to work with people that you feel have caused you wrong. What is your view on that?
No, it happens in life and in work environment that you will differ as colleagues and then work must continue. There's really no issue.
Yes.
Yes.
But you will be happy to go back and to continue with your work without any feeling of animosity.
Indeed.
And the president should not be concerned that this act of suspending you and taking you to a disciplinary hearing has somehow impacted your ability to fulfill the functions as the Director of Public Prosecution.
Not at all, except that in terms of the life outside there, and family and whatever, that this obviously they also would like it to be concluded. And if it's concluded that indeed I'm innocent and the like, the president had to follow this due process for him to be able to make a determination, and I've got no quarrels with that.
Thank you, Madam Chair. I have no further questions for the witness.
What are you saying about family?
Once you're being accused for almost 7 years, you're in the media, you are corrupt, you are captured, there are these decisions. It affects everybody around me to say, really, are you that corrupt? What's happening? And they're like, then you have to explain yourself over and over again. And that at times you sit with them and then you look through their eyes. You can see that they are so much worried about this conduct and the like. But now that this inquiry, since the start of this inquiry, and they hear that there is nothing about me being corrupt and all sort of things, there's just is that burden and all sort of things, and to me as a person as well.
You must be happy that the president agreed to institute this, to establish this inquiry.
Indeed. Everybody around me, they said that this is the best that could have happened, because if this did not happen, I just maybe decided to resign, to leave, and what have you. The truth that South Africa knows now, they would not be in a position to know.
Well, this panel has not made any decision thus far.
Yes.
But at least South Africa has been listening.
Yes.
And your family has been following these proceedings.
Yes.
Listening to witnesses.
Yes.
And making their own view. But this panel has not made any decision whatsoever.
Yes, I'm now referring to my family, and I like to say to them, this has been a good opportunity, and that has presented them with the opportunity to really see what is happening and understand from that background.
Because they've listened to the witnesses who testify.
Yes.
Thank you.
Thank you, Madam Chair. I've got no further questions to the witness.
You are closing your case?
Well,
I mean,
after he's
insofar
crossed,
as this witness is
so far as
concerned.
this witness is concerned, yes. I'm going to close my case very soon, Madam Chair. I know that I should.
Yes, that ends the evidence in chief of Advocate Chauke. We will take